cumulative impacts, environmental stressors, community benefit agreements, environmental justice areas. These are some phrases you'll hear over the next 3 years as the Minnesota Pollution Control Agency develops regulations to implement Minnesota's new Cumulative Impacts Law. To understand what these things mean, consider decades-old permitting and zoning decisions made by local, state, and federal governments. For many neighborhoods and communities in Minnesota, those decisions have led to industrial and manufacturing facilities that create heavy pollution being located near homes, schools, and parks. Today, too many Minnesotans are disproportionately exposed to harmful pollutants. To address this problem, the Minnesota legislature in 2023 passed a law asking the MPCA to examine the combined effects of past and current pollution, or cumulative impacts, in some parts of the Twin Cities 7-county metro area, as well as the cities of Rochester and Duluth. Specifically, the MPCA must focus on new and existing facilities requiring air permits located in or within 1 mile of an environmental justice area in the communities identified within the law. While the Cumulative Impacts Law is new to many in Minnesota, facilities located in parts of South Minneapolis have been required to conduct similar analyses since 2008, and states like Massachusetts and New Jersey have also recently required them. For the first time, the legislature defined an environmental justice area in Minnesota law. An environmental justice area is one or more census tracts, small permanent subdivisions of a county or a city, meeting any of the following criteria. 40% or more of the population are people of color. 35% or more of households have an income at or below 200% of poverty, meaning about $60,000 for a family of 4. 40% or more of the population over the age of 5 has limited ability to use the English language, or located within Indian country, generally meaning within the boundaries of a federally recognized tribal nation. In the Twin Cities, about half the 7-county metro area is in or within 1 mile of an environmental justice area, including the cities of Minneapolis, St. Paul, Burnsville, Woodbury, Brooklyn Park, and Blaine. In Duluth, approximately 2/3 of the city is in or within 1 mile of an environmental justice area. In Rochester, it is more than half the city. The Cumulative Impacts Law applies to new facilities as well as some current facilities that are expanding or require a new air permit. Based on the legislature's criteria, approximately 120 current facilities, including landfills, power plants, refineries, and manufacturing plants, may be impacted by this new law. You may review a full list of these facilities on the MPCA website. A major part of the new law is a cumulative impacts analysis, which is intended to be a comprehensive look at past and current pollution burdens that affect a community or neighborhood. This additional environmental analysis will better guide permitting decisions and protect the environment and health of residents in the community. When a company applies for an air permit, either for a new facility, a project to expand a facility, or to renew an existing permit, the MPCA will be responsible for determining whether a cumulative impacts analysis is required. If so, the agency must also determine whether issuing the permit would substantially impact the environment or health of nearby residents. There are several ways a cumulative impacts analysis may be required, and each of them requires relevant and important evidence to support the need for analysis. First, if the facility exceeds any benchmark or criteria, additional environmental analysis is required. Those benchmarks have not yet been defined or determined, and the MPCA needs your active participation during this process to develop them. Second, the MPCA commissioner may require a cumulative impacts analysis if relevant information suggests that the facility's air emissions may substantially impact the environment or health of residents. The MPCA also needs the public's participation to develop the definition of a substantial impact. Lastly, the commissioner could also require an analysis if at least 100 residents in the affected environmental justice area petition and supply relevant information. This is the third area where the MPCA requires your active participation to develop a definition. If a cumulative impacts analysis is required and the MPCA determines the facility would have a substantial adverse impact on the environment or health of residents in the environmental justice area, then the company will be required to enter into a community benefit agreement before obtaining an air permit. Community benefit agreements have historically been used in redevelopment projects. In those cases, the agreement is signed by the community and the company or developers, and the company agrees to create or adopt specific benefits for residents in the affected neighborhood. In Minnesota, community benefit agreements were used during the construction of the Central Corridor and a redevelopment plan in Minneapolis's Harrison neighborhood. In the MPCA's situation, this will be the first time the agency has used community benefit agreements. This type of agreement, which is developed with active community input and participation, will be a legal and enforceable contract between the agency and the company. The MPCA will be working with Minnesotans to develop a community benefit agreement process that actively engages and encourages the participation of nearby residents to address the specific needs of each neighborhood and community. We anticipate each community benefit agreement will be unique and address priorities within the affected community. Developing regulations to implement the new cumulative impacts law requires significant participation from Minnesotans and other stakeholder groups. The MPCA has approximately 30 months to complete its process. Our work is divided into several phases. We're currently in the scope and focus phase. That means, in addition to what is required in Minnesota law, the MPCA wants to hear from you on what else should be considered as we're developing these regulations. There are several opportunities to learn about the cumulative impacts law and this phase of the work. We are hosting 5 community meetings in an open house style format. We are also asking the public to submit comments through the formal request for comments process. You may do that through October 6th by using the Office of Administrative Hearings online portal. The next phase is the development phase, which starts in October 2023 and continues through April 2026. This phase is extremely important as we will include active participation to develop criteria and processes for the cumulative impacts analysis, the community benefit agreement, environmental stressors, and other items. We're expecting to hold numerous work sessions, open houses, community meetings, and other opportunities to develop these important items. Beginning in May 2026, we will enter the public notice and hearing phase. This is where the final proposed regulations will go through final public comments, a public hearing, and a legal review by an administrative law judge. If the judge decides that the MPCA's proposed regulations are reasonable, the regulations will be adopted and the MPCA can begin implementing them. A lot of work must be completed during the next 30 months. We need Minnesotans to be engaged in this process and help implement a cumulative impacts law that works best for Minnesota. Throughout the process, we will have numerous questions for Minnesotans to help answer. Please continue to follow the conversation and progress online.